In this video, we are going to be looking at the formal and essential requirements for validity of the civil marriage. Of course, we are also going to look at those requirements to be met before a civil marriage can be accepted as legal under the law. But of course, before we jump into that, it's very important for us to understand the definition of what actually amounts to a marriage. And after that, we'll then proceed to look at these formal and essential requirements for the validity of civil marriage. Hello there, my name is Mutiaba Conrad. I am a lawyer and a private law tutor. And before we start on our class, I encourage you to subscribe and also turn on the notification. And this will really help you because every time we release videos, this will always be brought to your attention. And then students interested in private law tutorial sessions, please feel free to contact us. Our numbers are down in the description box. We will be able to help you if you're having any challenges, either in law school or at the bar or anywhere. Please just contact us. Our numbers are down in the description box. So let's jump right into it. Let's start by looking at what exactly amounts to marriage, or what is the definition of a marriage. So basically, when you look at the definition of a marriage, the commonly used definition is the one which was stated in the case of Hyde versus Hyde, the case of 1863, basically where marriage was defined as the voluntary union for life of one man and woman to the exclusion of all the others. However, this definition really has been criticized and for a number of reasons, but mainly because it is shallow and discriminatory, and therefore it has been disregarded for being non-inclusive. Because when you look at it, for example, it doesn't cover aspects of the Muhammadan and customary and Hindu marriages, which are potentially polygamous. And then also, secondly, in other jurisdictions, marriage is not limited necessarily to being heterosexual, since in those jurisdictions, same-sex marriages are valid. So because of those two reasons, it has been highly criticized, and therefore a more inclusive definition of what actual amounts to marriage, especially in the Ugandan and also predominantly really in the African context, is as follows: that marriage, and this is a better definition really because it's more inclusive and it's not discriminatory, and it recognizes all the various types of marriages under Ugandan law. So a more inclusive and preferred definition of what actual amounts to a marriage is that a marriage is the voluntary union between man and woman for life, to live as husband and wife, to form a family under any of the existing legally recognized forms of marriages. So that is a more inclusive and better definition and all encompassing. So having properly understood what actual amounts to a marriage, let's now jump into the requirements to be met before a civil marriage can actually be accepted as legal, also known as the formal and essential requirements of a civil marriage. So here basically we are looking at those requirements of a civil marriage for us to say that such a marriage is actually legal. So the first requirement and essential requirement is the marriage must be strictly monogamous. This is really very important. So for a civil marriage, you cannot have more than one partner. Please, authority for that position, I encourage you to look at section 34 and also section 36 and also section 50 of the Marriage Act, Cap 250. It is very, very authoritative. So you cannot go on to carry out a civil marriage if, for example, you're married to another party under, for example, customary marriage. So, for example, if you're a man, you're married to Jane under customary law, you cannot then proceed to get married to Sarah, okay, under civil law. Okay, so if you're gonna marry someone under civil law, it must be the same person who you also married under customary law. So it is strict, and here polygamy under civil marriages is completely unacceptable. So let's proceed to look at the second requirement, which basically is that the parties must be of majority age. And under Ugandan law, majority age is actually 18 years. And please, I encourage you to look at Article 31, Clause 1 of the Constitution. It is very authoritative on that. The third requirement is that both parties must voluntarily consent. So there has to be an aspect of consent There has to be that aspect of free will. It's really very important. And again, I encourage you to look at Article 31, Clause 3 of the 1995 Constitution of the Republic of Uganda, which basically requires that there has to be that free will and free consent of both man and woman before they get married. Then the fourth requirement is that the marriage must take place within 3 months after the date of notice. Now, remember that under civil marriage, there is always that requirement of notice to be given to the public. And the moment that notice is given, then the marriage has to proceed and be carried on within 3 months from the date of notice. And this is a requirement of the law. I encourage you to look at Section 11 of the same act, which basically makes subsequent proceedings null and void and illegal if you proceed to carry out a civil marriage after the expiration of the 3 months after the notice has been issued. This is really very important. Number 5, under civil marriage, both parties must not be closely related by blood. So a brother cannot get married to a sister or something of the sort, and this is really very strict. Authority for that position, I encourage you to look at Section 10, subsection 1C of the Marriage Act, which prohibits the registrar to issue a certificate where there is an impediment of kindred. This is really very important. You can also interest yourself to look at the case of Bruno Chihuahua versus Juliet Namazi and Ivan Serunkuma, although this case actually applies more to customary marriages, but it will give you a good insight of how harsh courts will be in case you attempt to get married to a person whom you are closely related to. So let's quickly jump to look at the other requirement, which is basically consent of parents. So consent of parents is also another requirement. So in case you're intending to marry and you're below 21 years, please, this consent is required by virtue of Section 10, subsection 1B of the Marriage Act, which requires the consent of parents where the parties that intend to get married to each other are actually below 21 years. But however, it's also very important to add that because this is a provision really of the Act, but when you look at the Constitution, Article 31, Clause 1 of the Constitution, it entitles as a matter of right all persons who are above 18 years to actually go on and marry. So whereas the position of the Act is that you have to get the consent of parents, this is desirable, but please note it is not mandatory, meaning that even if you do away with it, it cannot necessarily invalidate a marriage because of Article 31, which makes the age as 18 for you to be legally grounded to go on and marry. So this aspect of consent from parents, it is desirable, but it is not a mandatory requirement. Even if you left it out, it would not invalidate a civil marriage that has been lawfully executed. Let's now proceed to look at the other formal requirement. Those are parties must not be of the same sex. So it's important to note really that under Ugandan law, and quite a number of African countries, with the exception of a very few, same-sex marriages are still prohibited, and authority for that position under Ugandan law is Article 31, 2A of the Constitution, which basically prohibits same-sex marriages in Uganda. You can also look at the case of Corbett. It's authoritative, Corbett versus Corbett. It's a case of 1970, volume 2, All England Law Reports, page 33, where it was also held that same-sex marriages are prohibited. Let's now also proceed to look at the other requirement, which is basically that both parties must not knowingly, and please note here the word is knowingly and willfully, acquiesce in the celebration of the marriage in any place other than the office of the Registrar of Marriages. Of course, the exception there being where it has been authorized by the minister. Please, I encourage you to go and interest yourself in looking at Section 34, subsection 2A of the Marriage Act. It's authoritative, meaning that a civil marriage strictly must be carried in the office of the Registrar of Marriages and not in any other place. So if it's going to be carried out of that office, then you have to get the authorization by the minister. You have to get a license allowing you to celebrate it in any other place apart from the office of the registrar. So that is also a requirement under the law. Let's proceed and we'll look at another requirement, and basically this other requirement is that a marriage celebrated under a false name or names. So it is not allowed for you to proceed to celebrate a marriage. For example, if you are called Mutiaba Conrad and then you proceed to celebrate a marriage under the names of Vachinene Pius, this would not really be acceptable, and it would be a ground to squarely invalidate such a civil marriage. Authority for that position, I encourage you to go on and look at section 34 subsection 2b of the Marriage Act. It is authoritative on that. Let's now proceed to the other requirement, which is that a marriage celebrated without the registrar's certificate of notice. So this certificate of notice is a requirement of law by the registrar, and it must be given. And if you proceed to celebrate your civil marriage without this certificate of notice, the same would be invalid. Please look at section 34 subsection 2c of the Marriage Act. It is authoritative on the same. The other requirement, and which is the last requirement, that is requirement number 11, basically is that a marriage celebrated by a person not being the recognized register of marriages. So in essence, civil marriages have to be strictly celebrated and executed by a recognized register of marriages, and this is a requirement of the law. Please look at section 34 subsection 2d of the Marriage Act. It's only that recognized register of marriages that must proceed to carry out this civil marriage, less of which it would be null and void. So those are basically the formal requirements. And in conclusion, ladies and gentlemen, it's important really to note that breach of any of those requirements which I just shared with you makes a marriage void, null, and illegal from the beginning, and of no legal consequence at all. Please look at section 34 subsection 2 of the Marriage Act. It will give you more light on that. So you have to ensure that you strictly comply to those requirements which I just shared with you, less of which surely it's a total wastage of time. Such a marriage is null and void, and it will not be recognized by the law. So basically, ladies and gentlemen, those were the formal and essential requirements to be followed that must be complied with to ensure that a civil marriage in Uganda is legal and properly valid. Again, ladies and gentlemen, we have come to the end of our class. Ensure to subscribe to my channel. Turn on the notifications so that every time videos are released, this is brought to your attention. And then also share and like this video with your colleagues so that they're able to benefit. And then students interested in our private law tutorial sessions, please reach out to us. We'll be able to help you. Our contacts are down in the description box. Thank you very much.